Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential. And here's your host, Jeff Crank.
Well, welcome to another edition of American Potential. Now, this time, just a quick hit on an interesting topic that's happened just recently in the news. So, how would you interpret the word reasonable? One person's reasonable might be someone else's unreasonable. Yet the administrative state has managed to impose its version of reasonable to make rules and regulations for the past 4 decades. Now, they've been able to do this because of a 1984 Supreme Court case that set legal precedent for courts to defer to the agency's reasonable interpretation. And in 2020, the National Marine Fisheries Service, which is a part of the National Oceanic and Atmospheric Administration, also known as NOAA, wanted to increase monitoring for herring fishermen, but lacked the funds to support it. Consequently, they decided that the fishermen should cover the costs. Now, the average expense for these monitors was around $700 per day, which could exceed the daily earnings of the fishermen themselves. As a result, the fishermen took legal action, and the case eventually reached the Supreme Court. Now, last year, we had fisherman William Bright and Ryan Mulvey, who is counsel for Cause of Action Institute, on the podcast to talk about the case before they found out that the Supreme Court was going to review it. Well, I want to welcome back Cause of Action Institute counsel Ryan Mulvey and one of the other fishermen in the case, Wayne Reichle, to the podcast to talk about the Supreme Court ruling. Thank you, gentlemen. Thanks, Ryan. Thanks, Wayne, for being with us.
Thanks, Jeff.
Thanks for having us, Jeff.
Yeah. Well, let's start with you, Ryan. This case, what was the 1984 Supreme Court case that gave the administrative state sort of the ability to make these rules and regulations?
Sure. So as you mentioned, that case was called Chevron versus Natural Resources Defense Council. And the facts of that case, which are important to understand, was a debate over the meaning of an undefined statutory term. That statutory term was stationary source. And the EPA had its own definition that it had come up with in understanding this portion of the Clean Air Act. And relevant here, what the court ultimately said was that when there is a statute and the statutory phrase is undefined, it's ambiguous. If there's that ambiguity, then a reviewing court should defer to the agency's interpretation of the law, so long as it is permissible or reasonable. I mean, obviously, that is a gross simplification of that case, but that's the gist of it. And it created 40 years of legal development of something that we consequently call the Chevron doctrine or Chevron deference. And I mean, that basic two-step process for deferring to agency interpretations of law became very Byzantine, and there was a lot of modifications by the Supreme Court and in different circuits as to how we actually go through the two steps. And but at the end of the day, the problem with Chevron and why it became so important to get the Supreme Court to review it in this case and to overrule it was that it created this weird situation that, unlike in regular litigation, when two parties who aren't the government go to fight over the meaning of the law, the court provides its best interpretation of the law. It decides the case. Chevron instead created this weird situation where when an agency is involved and when a party is suing the government gets a huge, benefit. The thumb is on the scale for the government. Judges, instead of having to grapple with hard questions, could often just put up their hands and say, look, I can't figure out what the meaning of the law is here, and I'm going to defer to the agency. And that allowed agencies to get away with quite a bit. And it was particularly egregious in this case because we had a statute that was silent about a general authority to require industry funding for these monitors. And the agency said, well, the law doesn't say I can't do it, doesn't say we can't do it. So it's reasonable to expect that we have the authority to do it. And that's just so backwards. Um, so getting rid of that whole regime of deference and putting back judges into the job of telling us what the law is and of interpreting the law is just a tremendous win.
Yeah, you raise a good point that actually I hadn't even thought of with regard to Chevron and how this was interpreted. If two private parties sue one another, it's really the judge or the judicial branch that is the arbiter of that, right? But it seems like with Chevron deference in place, prior in place, that it wasn't the judge who got to decide that. It was basically the agency because the court gave their authority kind of to the agency to interpret. I mean, would you agree with that?
Oh, I think that's absolutely right. So, and not only that, but even worse, Chevron and the whole idea of deference created an incentive, I would argue, for Congress to be more ambiguous in its drafting to not do its job under the Constitution, right? Because especially when you have your friends in the executive branch, you can either A, not legislate at all and let them do it through regulation or even worse by executive order, or B, keep things vague and let the president fill in the details, which gets the whole constitutional order backwards. The founders, we've been using this explanation a lot, and it's simplified, but it really gets at what's going on here. The founders envisioned that Congress would write the law, the president would implement it, execute it, and the judges would tell us what the law is when there's a dispute, right? Chevron created this situation where Congress wasn't doing the legislating, agencies were doing it, and they were doing it in ludicrous ways, such as here, where they were even bypassing Congress's power of the purse when they ran out of money to keep their preferred regulatory programs going. And then they were getting deference in the courts. So, and if this isn't this case, but there are other cases where agencies, they even have their own courts. So the agency is judge, jury, executioner, and it's just, we've gotten into such a ridiculous place with the administrative state and how imperial the presidency and the executive branch has become. Getting rid of this deference is a big step towards fixing the problem that we find ourselves in.
Right. Wayne, let me ask you, what were your thoughts when you first heard that you had to pay for a monitor to be on your boat?
That's a good question, Jeff. Our industries went under. We've been under extreme, regulation, through a regulatory process now for the past 30 years. Back in the 1970s, we were definitely overfishing, and National Marine Fisheries Service stepped in and started creating regulations and different mesh sizes, gear restrictions, and things to manage fisheries. And over the past 20 or 30 years, we've always carried fisheries observers on board our vessels. So, the fact that they came to us and said, now we want to have it mandatory coverage and we want you to pay $700 per day. First thing you say to yourself is, how can we afford to even operate our fishing vessels? We're competing in a sector that, there's herring caught in Scandinavian countries and in the UK and Canada. How can we compete, on a global scale with our fisheries if we're being charged and we're forced to pay these excessive costs? Needless to say, our boats drive around the ocean sometimes for 6-7 days at a time, never set their net, never catch a fish, and the crew comes in and they've got a fuel bill they've got to pay for, they've got food expenses they've got to pay for, and now they've got a $700 a day observer coverage fee that they have to pay for. So it was pretty shocking. We asked ourselves how we could do it, and the simple term is, simple sense is we couldn't. I mean, we just couldn't continue to operate that way.
Right. So then you Talk about the decision to take this case to court. I mean, not there's lots of herring fishermen, right, around the
Well,
country. There's lots of people that have confronted Chevron before,
right.
things like that. What made you decide you had to do this?
Well, there's not a huge industry left for herring anymore, Jeff. There's probably less than 10 boats fishing herring today, which really pushed us over the edge. And we're thankful for the Bright family and the Axelson family, both unload their catch here at Lund's Fisheries. They agreed to join the case with us, and the focus was just always trying to beat this and keep the observers off the boat. As a small business owner, I never knew what Chevron deference was until this case was brought upon us, and working with Cause of Action and their team, that's when we realized the importance of this, not only to our case, but really to the country.
Right. Right. So talk about how did you feel when you heard that the Supreme Court of the United States was going to take this case? That must have been an interesting moment when you found that out.
Yeah, I mean, it was super exciting to think that our case was going in front of the Supreme Court. And I would say that during the whole process, we weren't really focused on. We didn't really know the complete scale that this meant, right? I mean, for us, it was always about just being able to operate our business and being able to continue to make money and provide jobs for our fishing crews and families. It's critical business here to our community in Cape May.
Yeah. Ryan, well, I guess this will be for both of you. Let me start with Ryan. What was it like leading up to the oral arguments in this case, Ryan?
Yeah, well, I mean, I'll start by reiterating something that Wayne mentioned, which is that from the get-go, we did not expect this to become a case about Chevron deference and overturning the Chevron doctrine. For us, from the get-go, it was always about this is such an egregious instance of an agency doing something that it's not allowed to do, and that if it got away with it, would have just disastrous economic impact on the regulated industry. So we never imagined until we got to the DC circuit and ended up fighting over. We didn't even at the DC circuit. It even really wasn't a question of whether Chevron should be overturned. It was a question of, well, now really, how does Chevron apply here, and did the district court get the application of Chevron right, and what does the text really mean? So we never imagined when the court took this case and decided we don't want to really talk about the Magnuson-Stevens Act, we want to talk about Chevron. We realized, wow, this is going to become the vehicle for possibly taking down Chevron, and that was just super exciting. We retained Paul Clement to argue the case in front of the Supreme Court. He's former Solicitor General of the United States and one of the top constitutional, if not the top constitutional lawyer and Supreme Court litigator in the country. And I think we were all super excited and honored to be able to work with him and to see that sort of lawyer operating on that sort of level. And as we got closer and closer to oral argument, I mean, it just began to sink in the significance of what this case would become. And I mean, I'll just say personally, this isn't really about the case, but being able to sit at counsel table in the Supreme Court, I mean, the tables are so close to the dais. And I mean, I think I was looking up into Justice Gorsuch's nose. I mean, we were like right there, and it is a different atmosphere than any other courtroom. It's it's both solemn, but there's a casualness almost to the demeanor of the judges, because this is what they do all day, every day, while the court is in session. And it was as a lawyer personally, it was quite an honor to be able to be there and to help be part of this effort. But coming out of oral argument, I mean, we really had to take a breather and recognize that when the decision came out, it was going to be, no matter how it came out, it was going to be one of the most important cases of the term.
Yeah. Wayne, how about you? Were you leading up to oral arguments, what were your thoughts? Were you in the court during oral arguments as well, or?
Yeah, I was fortunate enough to be in the court, and that was just an amazing experience. Watching the Supreme Justices ask questions about the case at a level that I just can't explain. It was a really special moment. And again, I mean, we walked in there just very laser focused on our issue, and I don't think it was until after we left the court that day that I realized how this could potentially shape history moving forward.
Yeah, not bad for just a little old herring fisherman, right? You probably thought that yourself, like, how did I wind up in the United States Supreme Court? I'm sure it was kind of an amazing moment for you, right?
I think myself and Bill Bright, Steve Axelson, and all the people that helped us work on this case, Ryan and his team, we definitely all were questioning ourselves on the way into the Supreme Court, like, how the hell did we get here?
Yeah.
It's real. If I can interject,
Yeah.
I would say it's really appropriate, though, that that in this case that brought down Chevron deference, it wasn't big corporations, right? These were everyday Americans, small business owners, and it just goes to show you, for everything that might be in the media or in the legal commentariat, the talking heads, criticizing what the court has done or whatever, what have you. Deference and the administrative state impact everyday Americans. I mean, most of our life is governed by regulation from federal agencies and not by Congress's statutes, right? I mean, every aspect of our lives is controlled by these federal agencies. And, folks who have money and lawyers and, they're able to do all right. But it's folks like the herring fishermen who are already dealing with such burdensome regulation. They don't have the help. They don't have a chance against the federal bureaucracy. So I think that the facts of this case in particular, not that the justices were swayed by sympathy for the fishing industry, although it is a heritage industry, it's one of the oldest in the country, right? It's iconic. I think that the majority saw, wow, this is Chevron. I think Justice Gorsuch even said it during oral argument. This is a perfect case demonstrating how deference and bureaucratic hubris and the administrative state are just hurting everyday people.
Right.
Yeah.
Yeah. And as I think back, you're actually, Wayne, you're the second plaintiff in a Supreme Court case, a major decision by the Supreme Court that's been on this show. We had Joe Kennedy on the show, who was the coach who was fired for praying on the football field, and it was a landmark Supreme Court decision. And I was struck then, and I'm struck now, that these are ordinary people, right? You're an ordinary American who decided, instead of just laying down and saying, well, this is just the way it is and the way the government does it, I mean, you decided to stand up and fight back. But you didn't just fight back for you. You literally have fought back for every single American. I mean, it's really heroes that stand up and do this. And I'm sure it wasn't easy to go through that. I mean, as you look back on that, and I want to get your sense of when you heard the decision that came down, but as you look back on that, could you have ever imagined being where you are today when you first decided, well, yeah, I guess let's go forward with the lawsuit?
No, Jeff. Our industry is a big industry, but we're often we're full of various size companies within our industry, right? You have people that own fleets of boats. We have a lot of independent owner and operators that own one boat. But at the end of the day, we're all fishermen, and we always fight these regulations together. We may not always agree on everything, but the common sense rules like this, we fight, and that's what we did in this case. We had to stand up for ourselves and fight for what we thought was right for the industry. Not only just because of us herring fishermen, but this was a vehicle to move into other fisheries that we're operating in, other space that we're fishing in. So this wasn't something that was just going to end with herring. This is something that would have wound up happening with squid and other species that we're fishing with, and would wound up being a cost that we have to deal with for decades to come.
Sure. So when the Supreme Court ruled in your favor, how did you feel when you heard the news? I mean, how did that? I'd love to hear that moment for you, Wayne, when that news came down.
My wife and I were actually in a meeting with two other ladies, and I walked out of the meeting because my phone started blowing up, and I was advised that we won. And I came inside and I was like, we just won a Supreme Court case, and everyone kind of looked at me like, okay, well, what does that mean? And I couldn't wait to get out of the meeting and finish that up, because it was personally, there's a lot of satisfaction there. I think that we were super privileged to have cause of action, working for us and representing us in this case all the way through, and just knowing that that this is part of history in the making, I think is just a very special moment.
Yeah, that's great. Ryan, how about you? I mean, obviously you had some belief that it was going to come down. We kept thinking it was going to come down, then it didn't, and the Supreme Court releases decisions on certain days. But how about you when you found out?
Yeah, every morning of an opinion day, we're there, 10 a.m. refreshing the court screen, because we don't get any sort of advance notice, even though we're a party to the case. I mean, obviously, there was the moment that it came out was the whole office blew up, because everybody is in their office on their computer checking the court website. But then I don't think it really sunk in immediately, because we immediately had to, we were reading the opinion and analyzing it and pulling out the key legal, the issues identified by the court, and the dissent and the concurrences, and taking care of media and press. And it wasn't really till the end of the day that, that it sunk in, particularly as a lawyer, because, you go to law school, you take administrative law. Chevron is such a huge part of where we are with it, or was, with administrative law. And, for that just to all be swept away, it's a funny anecdote. On Twitter, there's a Harvard law professor, Lawrence Tribe, and Larry Tribe posted, he's like, the people I feel most sad about are the law professors who have based their whole careers on this, which at one level is just like, a typical, case A, exhibit A in the disconnectedness of portions of the legal academy from the real world. But also, I mean, it is true. That's how significant this is. We have people whose whole careers now, their whole academic research has to be, has to pivot to something else. And so that was just satisfying.
Yeah.
And Jeff,
those poor law professors. I
know, right?
Bad for them, don't you? Poor Lawrence Tribe.
I was just going to add to that, Jeff. Ryan, one of Brian's team members, I sent him an email and said, "Hey, congratulations, guys," because I hadn't heard from anybody yet. And one of his team members emailed me back and said, "We're not done yet." So we still have to go back to the lower court and reread this. But not having Chevron deference there is going to, I think, hopefully will help us.
Well, it's a giant decision. And Ryan, maybe sort of last question here, but just talk about the decision itself. I mean, it's not only does it affect the fishing industry and these specific plaintiffs, but other industries as well. I mean, this is a big landmark decision. Talk about maybe the impact this could have on the entire government. Yeah.
Well, it might even help to just kind of encapsulate what the Chief Justice wrote in his opinion for the court, and what is actually the holding here. So Roberts started by looking to the Constitution, and the seminal case of Marbury versus Madison, and saying that, look, Article 3 gives courts the judicial power, and the judicial power means deciding legal questions according to a judge's best judgment. And that in the administrative law context, when we're dealing with federal agencies, the Administrative Procedure Act tells courts under a de novo standard of review that they are tasked with deciding questions of law. And so then, very fundamentally, it is the job of the judge, when presented with a statute, to construe its meaning and to tell us what the law is. And that saying that there's an ambiguity and giving up your role as interpreter and letting an agency win is inconsistent with the idea of deciding the legal question. So this then applies across the board. Wayne mentioned that we're going to have to go back on remand because the court didn't actually apply its new standard for reading the law to the Magnuson-Stevens Act, which governs domestic fisheries regulation. But now any statute, that unless it has its own unique standard of review incorporated into it, the default rule is going to be when there's an administrative law case and a question of law about the organic statute, about the applicable statutory provision, the judge is going to have to do the job of finding out, resolving ambiguities, finding out what silences may or may not mean, or explicit undefined terms, construing them. He'll be able to use all the traditional tools of statutory construction. He'll still be able to take into account the agency's position. And the court explained that in cases where an agency's interpretation of the law is longstanding and was developed contemporaneously with the passage of a law, that's, there's no deference. But if that's a persuasive position that the agency gives, the court should take that into account. But ultimately, it's the judge whose job it is to tell us the law, and that's what the Constitution, or rather the APA, really requires. And that's now going to have. We're already seeing it. There have already been decisions. There was a decision, I think, on Title IX where the court said there's no more Chevron, so here's the best reading of the statute and why the administration's regulation needs to fail. There have been now in multiple cases judges who have said you need to rebrief everything, file supplemental briefs because Chevron's gone, and I need to figure out what the law says. Give me your best arguments either way, and you can't just say it's ambiguous, I win because I'm the government.
Yeah.
So
we've already had that in cases, even though this Supreme Court decision came down just days ago.
Yeah. Oh, yeah. It was immediate. And at a certain level, this should have already been happening. I think there is some, the court really didn't get into this, but the court, the Chief Justice did mention we haven't been using Chevron for a while at the Supreme Court level. We saw this development of major questions doctrine. I guess the future of that is a little unknown. There's some aspect of major questions that doesn't really deal directly with Chevron and ambiguity, but the court has kind of been trying to tell judges already for a while, you need to do a better job at actually engaging with the text and doing your job as interpreter. But there was some immediate orders coming out of lower courts. I will say that I think it's important to address one issue that the dissent raised, which is this fear that there's going to be a flood of new litigation, and all the past 40 years is unsettled. I think the judge, the Chief Justice, was very clear that principles of stare decisis can still apply. It's not necessarily true, particularly because many statutes like Magnuson-Stevens have their own statute of limitations or conditions for when a legal challenge, facial legal challenge, needs to be brought. I don't think we're going to see a flood of new litigation, and even we're just replacing the methodology. So older decisions, may still stand. I don't think the sky is going to fall. And if Congress wants to delegate to an agency some explicit, discretionary authority in construing the law, Congress needs to do that. So maybe we'll also see in the long run Congress do a better job at drafting laws and, doing what it's supposed to do under Article 1.
Yeah, right. Well, good. Wayne, any final thoughts? I'll give you the opportunity. Any final thoughts on this decision?
Just it's just a great moment in history, Jeff, and I'm very thankful for Cause of Action. Very thankful for my family, all of our employees here at Lund's Fisheries, and all of our crew members and fishermen on board our fishing vessels for sticking with us through this. And it's just a great moment in time.
Yeah. Well, I want to thank both of you for sharing your story with us, and for going through this for the American people. And so thanks for being with us today.
Thanks, Jeff.
Thanks, Jeff.
Yeah, you bet. So this is a prime example. I talked about Joe Kennedy and what he went through as the plaintiff that went all the way to the Supreme Court, and he talked about some of the sacrifice that he had, even to the point where losing his job. His wife worked for the school district that was the defendant in the case, and the difficult nature of some of the relationships there. But these are decisions that Americans make, and they make it for us because it's only through their action, their standing up against what they perceive as the excess of government, that we're able to live as free people and to change things. So, it's also great to live in a country where you have the ability to go ask for a redress of grievances here in the United States and go to court. So these things are important. Liberty and freedom are important. They're easily taken for granted. You can't ever take them for granted. You have to be like Wayne and the other plaintiffs in this case. Go out there, defend freedom, defend liberty. Thank you for joining us.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.